Right now, Alaska Airlines pilot Joseph Emerson is on suicide watch after pleading not guilty in an Oregon courtroom Tuesday for trying to bring down a flight. Emerson is facing 83 counts of attempted murder, another 83 for reckless endangerment, and one for endangering an aircraft. He's also charged with the federal crime of interfering with a flight crew. The off-duty pilot was riding in the cockpit jump seat when he told the pilot and co-pilot, "I'm not okay." He's admitted to then grabbing the red fire suppression handles to shut down the plane's engines off. Emerson claims he was having a nervous breakdown and had not slept in 40 hours. He also told police he'd been depressed for 6 years and had taken psychedelic mushrooms 48 hours prior to the flight. Welcome back, everyone. I'm Tram Mai, along with attorney Hector Diaz of Diaz Law. Let's talk about this and go into a deep dive. 83 criminal charges of attempted murder, another 83 for reckless endangerment. Are these appropriate criminal charges given the fact of his history with depression and that, he needed help clearly?
So, it's something that undoubtedly you're going to have prosecutors looking at the totality of what occurred here. Right now what they're looking at are the facts that have come out from that incident, which is he engaged in just some exceedingly reckless acts, made admissions that, he was going to do something, and then ultimately tried to shut down the engines and even open an emergency exit. So, really troublesome. I think you have state prosecutors. So you really have two different entities here. You have the Oregon state prosecutors that are looking at the attempted murder charges given the passengers and given the inherent recklessness of the conduct.
Right.
And then you've got the federal authorities looking at interfering with the flight crew, which is that's a 20-year maximum punishment if he's convicted of that offense. And he's made admissions that he's not contesting that.
Yeah. Okay. But does the pilot have a defense because of the fact that he was hallucinating on mushrooms?
Probably not. I think it's really we're talking more about mitigation, maybe, limiting punishment, maybe really trying to put this in the right perspective that you are dealing with somebody who's mentally disturbed. The mushroom, the fact that he took these mushrooms and then got on the plane, they're going to look at some of the statements that he made, that he was aware of certain acts that he was engaging in, whether these acts were voluntary or not because he was hallucinating. No doubt his defense attorneys are going to look at that and raise these arguments, but that could be an uphill battle.
All right, finally, we want to get to the case of Brian Kohberger, the man charged in the fatal stabbings of 4 University of Idaho students. Kohberger will return to court today for 2 hearings where his attorney will ask a judge to dismiss the indictments against him or send his case back to a preliminary hearing. Kohberger is facing 4 counts of first-degree murder in the November 13th killings. He's being held without bail, and the judge has entered not guilty pleas on his behalf. All right, so Hector, what's at the heart of the defense to dismiss this indictment?
This is actually a really interesting motion that was filed by the defense. They're essentially saying that the grand jury process, it's a secretive, one-sided presentation by the prosecutor in order to charge Kohberger with the murder charges, that it was flawed, that it was biased, that they didn't present all of the evidence to the grand jury in order to get these charges. And if that's true, and there's a transcript, they're going to be making these arguments that had this presentation been fair, they wouldn't have indicted Kohberger. And so it's, this, I think this hearing was sealed from the public, but I think we're going to hear later what the evidence was. And that's going to be critical here. Was it clearly exculpatory evidence? Was it something that, had it been presented, would have changed the grand jury in terms of their charges? Then, we could see, again, not the charges being dismissed.
Right.
But, his defense concedes this, really what you're going to see is they're going to go back and have a hearing, and it's going to be a preliminary hearing, kind of like a mini trial, where now his attorneys are going to be there, and they're going to be able to test the evidence through cross-examination.
As a criminal defense attorney, though, what are your thoughts on his defense?
It's interesting. It is. And no doubt that his defense attorneys got a hold of that grand jury transcript and had real concerns in how the entirety of the evidence was presented to the grand jury. Again, grand jury process, those hearings are secretive. We won't get access to the transcript, but we're going to get access likely to the motions and some of the arguments. But it's an argument. It's going to depend on what the evidence was and some of these biases and how the evidence was presented by the prosecutors. We could see a bit of an issue here in terms of this matter.
All right. Well, we thank you so much again for all your time, from the manhunt to these 4 cases. Thank you, Hector.